It's been a busy year in the law at work and in my columns in the Union Tribune that run every 2 weeks. I want to talk briefly about the 3 top developments that I have discussed in my columns this year. First, the California Supreme Court issued a landmark ruling called Dynomax about the distinction between independent contractors and employees for the purposes of the wage and hour laws. A person is an independent contractor only if 1. The hiring entity does not exercise the kind of control that would normally be exercised over an employee. 2. The work of the particular worker is not integral to the work of the hiring entity, the company, if you will. And 3, if the worker is engaged in an independent profession. Now, it's important to be careful here, because it is not enough that the hiring entity doesn't prohibit the worker from engaging in other kinds of work. The worker has to be engaged in doing his or her work for other hiring entities. The second one is the California legislature had its Me Too moment in enacting new laws related to sexual harassment in the workplace. It started by announcing 5 different elements that courts should consider in evaluating claims of sexual harassment. And here's one that's really important. For the first time under California law, California courts are not going to be able to distinguish among the different kinds of workplaces in deciding whether sexual harassment has occurred. What does that mean? It means that sexual harassment in a lube shop and that kind of comment is going to be treated the same way as similar comments in, well, a law firm or a library. And in addition to that development in that particular piece of legislation, employers are also not going to be able to extinguish claims of sexual harassment preemptively by having their employees sign something saying, I'm not aware of any kind of sexual harassment, in exchange for the right of the employee to engage in continued employment. Again, as part of the same comprehensive legislation, employees are going to be allowed and cannot be prohibited from disclosing unlawful actions in the workplace. The third and final development I want to discuss deals with public employees. Now that's important because according to one study, 5 of the top 10 employers in San Diego County are government employers. The United States Supreme Court issued a major ruling saying that those kind of employers can no longer require its employees to pay agency fees to unions to support the cost of collective bargaining and other activities that are related to the essential kind of things that workers do. The reason that's important is because it could have an effect on unions' finances, and that could have a broader impact more generally.